Okay, picture this. You've gone through the whole patent appeal, argued your case to the board, the PTV, and bam, the decision lands. But what happens right after that, it's often not the clear end you might think. It's actually a super critical moment for your application. Welcome to the deep dive. We're your shortcut to getting up to speed, diving into complex stuff to pull out the essentials, maybe some surprising bits, and just enough, well, interest to keep you listening. Today, we're really getting into the weeds of what happens immediately after a PTDIP decision. Specifically, we're looking at MPP Section 1214. That's the section titled Procedure Following Decision by Board. Our source material for this comes from a big educational series covering the whole Manual of Patent Examining Procedure, the MPEP. It gives us a really detailed view of this specific section. So we're here to sort of unpack the steps, the timelines, and, the big choices you might be facing right then.
Yeah, MPP 1214, it's really key because it explains that procedural handoff right after the board rules. It maps out how jurisdiction, who's in charge, usually snaps back to the examiner, but also what specific actions you, the applicant, need to take. And that really depends entirely on what the board actually said. Do they agree with the examiner, disagree, or maybe even throw in something new?
And before we dive in, a quick special thank you to Mike Shepard. He's the creative director who organized this entire audio series and gave us access to this material. Really appreciate it. Okay, so the decision is out. PTT has spoken. What's the general rule? Who gets the application back first?
Well, what's interesting is that typically jurisdiction over the application pops right back to the examiner, pretty much as soon as the board issues its decision. Think of it like the board saying, okay, we're done. Back to you, examiner.
Ah, okay. So the examiner's back in control. But you said the next steps depend heavily on the decision itself. Let's break that down. What's the ideal outcome?
Right. The most straightforward path, the one laid out in 1214, is if the board completely reverses everything the examiner rejected. If they reverse all the rejections, well, the application is usually seen as ready for action. And that action is often, allowance. That's generally the goal when you appeal, right?
Makes sense. A full win makes things easier. But okay, what if the board affirms rejection? Either all of them or maybe just some.
Right. This is where things get, let's say, more procedural, and you need to pay close attention. If any rejection gets affirmed, there are definitely extra steps needed before the case can move forward, or potentially get abandoned. And a really key point here is timing. There's a mandatory waiting period. The examiner actually has to wait.
Wait for what exactly?
They have to hold off until the appellant's time runs out, the time they have to take further action. That action could be asking the board for a rehearing, or it could be seeking judicial review, appealing the board's decision to a court, like the Federal Circuit.
Okay, and how long is that waiting period typically? Do we know?
The standard time referenced in the procedures is usually 63 days.
63 days. Okay, that's like 2 months. Gives the appellant some breathing room to figure things out. So what happens if those 63 days tick by and the appellant doesn't file for rehearing, doesn't appeal to court, and crucially, there aren't any allowed claims left standing?
That's the real deadline you need to watch. If no timely action is taken in that window and there are 0 allowed claims that could just proceed to issue, well then the application is simply deemed abandoned. Poof! So doing nothing has pretty serious consequences here.
Okay, now here's where it gets, I think, really interesting and a bit complex. What if the board pulls something unexpected, like introduces new grounds for rejection right there in their decision? The source material links this to 37 UDCA 41.50b.
Ah, yes. That's a very specific scenario, and MPP 1214 lays out a clear procedure for it. If the board itself brings up a new reason why your claims aren't patentable, something the examiner hadn't raised before, then you, the appellant, get presented with a distinct set of choices. You have to actively choose one to keep the process moving for those specific claims.
So you can't just ignore it. What are the options then?
Exactly. You can't ignore it if you want to keep those claims alive in the appeal context. You basically have 3 main paths, and understanding these is crucial. 1, you could choose to reopen prosecution. That means going back to the examiner. You'd file something responding to the board's new point, typically an amendment changing the claims or maybe new evidence, puts you back in dialogue with the examiner.
Okay, reopen prosecution. What else?
2, you can request a rehearing, but specifically on the board's new ground. You're basically asking the board itself, hey, could you take another look at this new reason you just gave?
All right, and the third option?
The third option is to file a request for continued examination, an RCE. That also gets the case back to the examiner for more prosecution, covering the new ground and anything else outstanding. It's a formal way to reset examination.
Okay, 3 distinct paths. But you have to pick one, right?
Yeah.
And within a certain time. Otherwise, what? You lose your chance on those claims.
That's exactly right. The procedure, referencing the rules for new grounds, usually gives you 2 months. 2 months from when the board's decision with that new ground is mailed out. And this is important, the board actually keeps jurisdiction over those specific claims affected by the new ground until you take one of those actions or until that time runs out.
Huh. That raises a question. What if you try to be clever and say amend some claims hit by the new ground to reopen prosecution? But for other claims affected by the same new ground, you ask the board for a rehearing. Can you split your response like that?
Actually, yes. The source material specifically addresses that kind of mixed response, and it shows how jurisdiction can literally split. If you amend some claims to reopen, but request rehearing on others facing the same new ground, well, jurisdiction divides. The board hangs on to the claims you asked for rehearing on, while the examiner gets back the claims you amended to reopen prosecution. It shows how precise you need to be.
Wow, okay, so the application can sort of be in two places at once, procedurally speaking? That's wild. What if you just think the board's new ground is completely off base? Can you just argue against it? File a response saying why they're wrong, but without changing claims or adding evidence.
The source is very clear on this point. If you only file arguments against the new ground, without also submitting an amendment or new evidence, that response is treated only as a request for a rehearing before the board. It specifically does not reopen prosecution with the examiner for those claims.
So just arguing isn't enough to get back in front of the examiner to talk it over. You have to actually file an amendment or evidence or that RCE.
Precisely. To get back to the examiner after the board introduces a new ground, you need one of those substantive filings, amendment, evidence, or RCE. Just arguing keeps you at the board level, asking them to reconsider their own point.
Okay. The source also had a really good practical example involving dependent claims after a mixed decision. Can we walk through that?
Yes, absolutely. It's a great illustration of what can happen with a partial victory. So imagine the board agrees with the examiner on rejecting your main independent claim, Claim 1. But they reverse the rejection for Claim 2, which happens to depend on Claim 1.
Got it. So Claim 2 is now considered allowable on its own merits, but its parent Claim 1 is still rejected.
Exactly. In that situation, to prevent the whole application from being abandoned, assuming no other independent claims were allowed, the appellant is actually required to rewrite Claim 2. You have to rewrite it so it stands on its own in independent form. Remove that dependency on the rejected Claim 1.
Why? What's the logic there?
Well, because depending on a rejected claim makes it kind of incomplete or improper from a procedural standpoint.
Yeah.
You need a valid, complete claim to actually issue as a patent. Now, the MPEP notes the examiner can sometimes help out and rewrite it via an examiner's amendment, but the guidance states the appellant is ultimately required to make sure it gets done. If you don't deal with it promptly, the application might just issue with only the rewritten Claim 2 if you do rewrite it, or it could even be abandoned if rewriting doesn't happen and there are no other valid claims left.
Yeah, okay. That is a really crucial detail to catch. Falling through the cracks there could be disastrous. What other sort of procedural nuts and bolts does MPP 1214 cover?
Well, the section also gets into some of the more maybe administrative things that pop up after a decision, like the formal steps for withdrawing claims you decided not to pursue anymore, or the procedures for filing things like terminal disclaimers. You might need those if claims are allowed, but there's a potential double patenting issue, for instance. Section 1214 tells you how to file it in this context, even if the reason why comes from other parts of the MPP. And it also nails down specifics on calculating and enforcing those timelines we talked about, like the 2-month deadline for responding to new grounds or asking for rehearing.
So it's really the playbook for managing the application right after the decision, covering all these little details. Does it ever allow for just reopening prosecution with the examiner after a final board decision outside of those specific scenarios like the new grounds response, like just trying again?
It does mention that, but it makes it very clear that reopening prosecution after a final board decision, setting aside those specific options like responding to new grounds, is incredibly rare, highly restricted. It generally requires written authority from the director of the USPTO, usually granted only under very specific rules like for certain petitions and really unusual situations. It's definitely not a standard option just to continue arguing with the examiner.
Got it. So the big picture here is that getting the board's decision isn't the finish line. It's more like a pivot point. And the specific decision dictates which path you go down with its own set of rules, deadlines, and required actions, all mapped out in 1214.
Exactly that. It's like a branching tree.
Mhm.
Reversal, affirmance, new grounds, those mixed decisions with dependent claims. Each branch has its own procedural requirements. Understanding those, knowing the deadlines, knowing the implications of each response choice, it's all essential for successfully navigating that post-appeal phase. It's how you avoid accidentally abandoning your application and make sure any allowed invention actually gets patented.
So what does all this mean for you, the listener? Clearly, handling the aftermath of a PT tape decision isn't simple. It's not just one path. You've got that 63-day waiting period to think about if rejections are affirmed. You've got those three distinct options if the board adds new grounds. You've got that specific requirement for rewriting dependent claims if their parent is rejected but they're otherwise allowable. MPP 1214 basically lays out this intricate map, and you really need to follow it carefully.
Absolutely. This section just hammers home how important it is to be really vigilant right after you get that board decision. Every possible outcome triggers specific actions and deadlines. And, missing a deadline or taking the wrong procedural step, it can have huge consequences, potentially even costing you the application entirely.
It really does show that the appeal doesn't always wrap up neatly with a simple yes or no on every claim. There are these critical follow-up steps that fall squarely on the appellant. You have to be proactive and procedurally correct. And for you, listening in, getting a handle on these procedures is that shortcut to being informed. It helps you anticipate the next moves or at least know the right questions to ask if you find yourself in this patent appeal situation. Okay, here's a final thought for you to chew on as we wrap up. We talked about those three options for responding to new grounds, from the board reopening with the examiner, asking the board for rehearing, or filing an RCE. Thinking purely about the procedural outcomes described in MPEP 1214. Which of those paths seems like it would give an appellant the best shot at having a direct back and forth discussion with the examiner about the substance of that new rejection? And how might that specific procedural advantage influence someone's strategy at that particular moment? Something to think about. All right, that brings us to the end of this deep dive into MPEP Section 1214, Procedure Following Decision by Board.
Yeah, we covered quite a bit how jurisdiction shifts, what happens after affirmance versus reversal, those crucial options for new grounds, and the necessary steps for things like dependent claims post-decision.
And just a quick heads up, this summary of the MPEP was put together using AI tools, including ChatGPT and NotebookLM. It might have errors or leave things out. It's really just for general educational and informational purposes. It's definitely not legal advice, and it's no substitute for proper formal instruction. For the official word, always check the official MPEP itself, talk to a qualified instructor, or consult with a registered patent practitioner. Thanks for diving deep with us.